Ladies and gentlemen, now I proceed to discuss another important aspect of this right of preemption as given under the scheme of Muslim personal law. What is the constitutional validity of right of preemption? Ladies and gentlemen, the constitutional validity of the right of the preemption can be discussed or studied under following two heads. Number one, before the constitutional amendment, and under the heading of after before the 44th constitutional amendment, in the light of before the 44th constitutional amendment 44, as well as in the light of after 44th constitutional amendment. In fact, dear learners, until the passing of 44 constitutional amendment in 1978, this amendment was passed by the parliament finally. Before the passing of 44th constitutional amendment, right to property was guaranteed as fundamental right under part 3rd, article 19, subclass 1, subclass F of the Constitution of India. Try to understand that before 44th constitutional amendment, which was made in 1978, the then government in power, immediately before this amendment, property was held by its owner as fundamental right. It was the fundamental right of the owner to hold a specific property, and no one could take away his this constitutional right against his wish or wishes, because it was a fundamental right, and fundamental right is inalienable right, non-compromising right. It is a sacrosanct right within the frame of the Indian Constitution. Therefore, since up to 1978, one was entitled to hold a specific property of his choice as a fundamental right. It was his fundamental right to hold a specific property so long as he wishes. And therefore, unlike many other constitutional rights, right to hold the property or right to own the property was also a fundamental right. And nobody was allowed to deprive the owner of this right without due procedure or without following the due process of law. Right to acquire, hold and dispose of the property. Article 19, subclass 5 provided that reasonable restriction may be imposed on this right of a person to acquire, hold and dispose of the property, yet it was protected under class 5 of Article 19. With the help of power exercised under this class, means in the exercise of this class, this right on the ground of the business or on the ground of consanguinity or on the ground of the participation of some immunity was held constitutional. Means that right to hold and dispose of the property was a fundamental right of the owner under Article 19(1)(f). But this right was not absolute, was subject to the restrictions incorporated under subclass 5. And subclass 5 provided that if a co-owner or co-sharer is wishing to sell his share, he should make the offer of the sale first to his co-sharer whose property by situation is in conjunction to the property to be sold. So, it was a kind of the restriction operating on the right guaranteed under Article 19 subclass 1. But this restriction basically under class 5 was a reasonable restriction. Being a reasonable restriction, owner was not allowed to, one who is the co-sharer or participator in the appendage and its immunities of property, was not allowed to sell his part or portion of the property to any stranger without taking into confidence his co-owner or co-sharer. Since the restriction given under class 5 was reasonable, therefore on this ground right of pre-emption was held constitutional until the passing of Constitutional Amendment 44. Means right of the pre-emption on the ground of co-ownership, Safi Sharik was entitled to claim the right of the pre-emption. Safi Khalid was entitled on this ground was entitled to claim the right of pre-emption, as well as the Safi Jar was also a rightful person to claim or assert the right of the pre-emption in the event his neighbor sold his property without informing to him or taking into confidence him. So up to 1978, or you can say up to the passing of 44 amendment, right of the pre-emption to the Safi Sharik, Safi Khalid and Safi Sharik was available and was held constitutional. And this right was held constitutional whether it was exercised under some enactment or under Muslim personal law. Therefore, in case of Bhau Ram vs. Baijnath, Supreme Court in 1962 held that pre-emption only on the ground of wishness was unconstitutional, cannot be. Means before up to certain 90 up to before the passing of this act, with this case, even right of the pre-emption on the ground of the neighborhood was also valid. But in 1962, this Supreme Court in Bhau Ram vs. Baijnath held that pre-emption on the ground of wishness was unconstitutional and cannot be enforced. The court held that unless the pre-emptor and the vendor or co-sharer are participators in some immunity, the right cannot be protected. Means Safi Khalid, the right of Safi Khalid was declared unconstitutional, but a right of co-sharer and participator in the appendage annuities was fully protected according to this decision, and this position was reaffirmed by the Supreme Court in Sant Ram versus Lab Singh case. After 44 constitutional amendment in 1978, Article 19 subclass 1 was repealed, and right to hold the property and dispose of the property was made only the legal right, not the fundamental right, not the constitutional right. It was because until the passing of this amendment, right to hold and dispose of the property was a fundamental right under Article 19 subclass 1. But by virtue of 44 amendment, this article was deleted, and nature of the right to hold and dispose of the property was also changed, and the change was that it became legal right from the fundamental right. Therefore, now after 44 amendment, this right to hold is not a fundamental right, or right to dispose of the property is not a fundamental right, but it is only a legal right. Thus, right to acquire, hold and dispose of is neither a fundamental right nor mere a constitutional right, but it is only a legal right. However, the pre-emption still continues to be a legal right. It is therefore submitted that reasonableness of the right of the pre-emption can still be examined under Article 14 and 15 of the Constitution. In Alam Prakash versus State of Haryana, Supreme Court held that claim of pre-emption on the ground of the consanguinity is ultra vires. The court observed that reasons which justified pre-emption in past, namely the preservation of integrity of rural society, the unity of family life, and agnatic theory of succession, are totally irrelevant. The court held that claim for possession by way of ground that claimant had superior right, being a preemptor only on the father's brother's son of the owner, cannot be sustained. Accordingly, Section 15 of Punjab Pre-emption Act was held to be unconstitutional by Supreme Court because there was no reasonable classification of co-sharer entitled to claim the pre-emption. After this case, Supreme Court, the next case before the Supreme Court was Krishna versus State of Haryana, in which the constitutionality of right of the pre-emption was again raised and examined under the Punjab Pre-emption Act 1923. While interpreting the Section 15 subclass 1b of the above Act, said Act, the Supreme Court held that the right of the pre-emption to co-sharer is valid and is not violative of Article 14, 15 and 16 of the Constitution. But Supreme Court in the case of Abdul Razzaq Sajan Sahib Bhagwan versus Ibrahim Haji Muhammad Hussain, EIR 1998 held that the right of the pre-emption could be claimed on the ground of being Safiye, could not be claimed on the ground of being, Safiyejar Vishnich. means the right of the preemption in this case was claimed on the ground of being Safi jar, having property in the neighborhood or adjoining to the suit house. The Supreme Court held that law preemption based on business was void and unconstitutional. Claim was dismissed. And it was also clarified in this case that the held that the right of the preemption based on the co-ownership or co-sharer or Safi Sharik and Safi Khalid is allowed, is valid, but the preemption based on the business is not allowed and is void. But after foregoing the discussion, we can make the following inferences. The statutory right of the preemption only on the ground of the business is now unconstitutional. In view of Bhauram and Abdul Razak Sajan case. Or it can be said that preemption on the ground of being co-sharer and Safi Khalid is that is the participator in the appendage and amenities is constitutional provided the classification of claimant is not unreasonable. It is necessary for a preemptor to satisfy the court that without claiming this right there would be personal inconvenience to him, that is preemptor. Suresh Chandra and others versus Suresh Chandra 2020. This is also case related to the right of preemption. And in this case also, this was decided by recently retired Chief Justice of India, Honorable Justice D.Y. Chandrachud. The issue in the present appeal was whether a right of the preemption was available to Beni Prasad, who is alleged to be the joint owner in the possession of disputed courtyard. This has arisen in the context of Rajasthan Pre-emption Act 1986. Case was in context of 1966 Act. The fact which have given rise to the appeal in brief are: a suit for preemption was instituted by Beni Prasad. B instituted a suit in the civil court. B died during his pendency of the proceeding and is was substituted by his legal representative. Beni Prasad, B and Kirori Lal were brothers, means B and K were the brother. B was the basically original petitioner or plaintiff, and K was the defendant. Both were the brothers. Beni Prasad filed the suit for preemption against the Devi Charan, who was the implicated as first defendant, and Kirori, who was implicated as the second, because Kirori Lal was basically owner and he sold his property to D, that is the Devi Chand. So in this case, B and K, Beni Prasad, Kirori Lal were the brothers, co-owners in a property. Kirori Lal sold his share to the D without following the rules of the preemption under the Act to be, and therefore B filed a suit claiming the property back from the vendee D in the exercise of his right of the preemption. After long drawn suit, the court held that Beni Prasad was entitled to the right of the preemption. as the best person because he was the co-sharer of Kirori Lal, who sold the property, his share in the property, without giving the offer of the sale to his brother B. Beni Prasad, and therefore right of the preemption arose in favor of the Beni Prasad, and Beni Prasad was entitled to claim the property from the D. Devi Chandra, who was the vendee in this case, and in this way his claim was accepted by the. It has been held by the Honorable Court that concurrent findings of the trial that the first appellate court and second appeal have proceeded on the correct interpretation of the provision, accordingly dismiss the appeal. Here both the segments were referred separated by comma, uh, and the court in the present case held that plaintiff Beni Prasad had a superior right of the preemption by virtue of the provision of section 6(3). Since he was the brother of the second defendant, that is the Kirori Lal, Devi Chandran has an inferior right of the preemption as compared to Beni Prasad. Hence, his claim cannot prevail over the superior right of preemption of Beni Prasad. So, in this way, the Supreme Court, in this case, that is in the case of Suresh Chandra and others versus Suresh Chandra, in 2020, again the Supreme Court on the ground of Shafi Sariq, right of the preemption was allowed under the Rajasthan Pre-emption Act 1966. So, friends, after 44 amendment, now this right of the preemption is not a constitutional right, not a fundamental right, but only it remains as a legal right. In view of deletion of Article 19, subclass 1. And Supreme Court of India in various decisions has affirmed that still right of the preemption is available in the form of the legal right, but validity of the right can be tested in the light of constitutional provisions 14 and 15 and other articles of the Constitution. In Alam Prakash versus State of Haryana, the Supreme Court has clarified the point well for the learners. In Krishna versus State of Haryana, also the Supreme Court held that right of preemption to the co-sharer is valid, allowed, and is not violative of Article 14, 15 and 16. In case of Abdul Razak Sajan Bhagwan versus Ibrahim Haji Muhammad Hussain, 1998, the court further held that right of the preemption on the ground of Shafi Sariq, Shafi Khalid is valid, lawful, can be invoked, exercised by the preemption. But preemption based on the neighborhood or business is not lawful, it is void, and hence it cannot be allowed to be claimed on this ground. And therefore, summary position is that statutory right of the preemption only on the ground of the business or neighborhood. Neighborhood is unconstitutional or illegal, is not permitted. Say for example, this is the house of A and this is the house of the B. B and A, they are neighbor of each other. Properties are in the neighborhood of each other. A, being the owner of this property, is selling his property to C. Preemption law requires that before offering the sale to C, A should have offered the sale to B. on the ground of business, but after this decision this raw preemption on the ground of the business has become illegal, void, and therefore, if A sells his house to C without following the rules of preemption, B cannot exercise the right of the preemption because he is simply the neighbor of A, and property of the A which has been sold to C is only in the neighborhood of the property of the B, and since on the ground of the vicinage and neighborhood right of the preemption does not exist, cannot be claimed, is not lawful, therefore B's right will be defeated by taking the plea that they are simply neighbor not. But if they have been co-sharer, A should have sold, then here right of preemption. If both were the participator in the appendage and immunities, say for example there was a common stair leading to the interests of both the houses, there they could have here A and B will be participator in the facilities, common facilities. Common facility is the staircase leading to the entrance of A to A property A and to the property of B. Here in this case also B could have been the preemptor, right of the preemptor would be available to him in case the property is sold by A without following the rules of preemption. So, this is all about law of preemption. I have already explained, and with this I thank